Aylen is managing partner in Gowlings, Moscow office, and his area of specialization is patentable, and in particular intellectual property right, which is the issue which is of great importance for Russia, neighborhood, and some other countries. But let me mention a little bit about the Gowlings company. First of all, David is Canadian, my fellow Canadian, so I'm delighted to have my fellow here. And so the Gowlings, the company exists in Canada more than 100 years, actually 125 years, and there's offices in many Canadian cities. But more than 20 years ago, it opened office in Moscow. It was the first, I think, international office of Gowlings, and I think 2 years ago, the company opened another office in China. It's also an interesting place in terms of intellectual property rights, as all we know. Anyway, it's a lot of business all over the place, and so there is a specialization of the company as a business law, but also intellectual property rights is one of the issues that David will be talking about, I'm sure. But what's important is to mention that it's, in particular, it's Russian or Chinese environment. The question is what does the patent mean, what's the protection of patents, what is intellectual property rights, and in particular, what is the money value of the patents, and also all these issues that David will be talking about. I'm delighted he came here. Thank you.
Well, thank you very much. I have the microphone. I'll stand up. First, thank you for coming just before the long weekend. I appreciate that you attended. And I would like to tell you a little bit about patents, but before I do, if you don't understand what I'm saying, or I speak too fast, or whatever, you can stop me, ask me whatever question you like. It's not a problem, so please ask. It's much better when we have a discussion than I give you a long lecture that is boring, perhaps. How many of you know what a patent is? Or a few? And you know that in Russia the patents are given to you by Rospatent, the Russian patent office, or also a Eurasian patent office will give you a patent here. And there are patent offices all around the world, mostly by country, but also some regions like European patent office. And I'm going to talk to you mostly about patents. And this talk is not so much about patents, but how you can make money from patents. And as is normally the case about making money, the Americans have taught us a lot about how to make money from patents. And so a lot of the things that I'm talking about are things that were learned with the US patent system, but the techniques they apply in any country. And it's particularly interesting for a country like Russia with new technologies and so on to know what the value of patents can be. And of course the patent is firstly something that is recognizing the inventor for having achieved something useful. But much more than that, after the inventor has invented it, then the question is, can it become a commercial and a commercially valuable asset that can increase the value of a company? So that's really what I'm going to talk about today. If I can work the projector. There we go. So the term monetization is an American term. I don't think the word is in the dictionary, maybe in a modern dictionary, and it means the act of creating money from something. So I'm going to talk about patent monetization. What is it? And when do you do patent monetization? And how do you do it? And how you do it is the most important part. Where is Where do I point this? Here we go. So what is it? There are many definitions of what is monetization. The simplest definition of monetization is it's a way to make money, of course. But the next definition, a little bit more academic or intellectual, is it's a way of generating cash from a portfolio of patents. Portfolio meaning a package of patents. In a company, usually a company won't have just one patent, they'll have many patents. And so monetization is a way of generating cash from a patent portfolio. What's another definition of monetization? A little bit more complex. Monetization is a technique to make an IP asset a liquid asset from which to profit. So a liquid asset, do you understand that term meaning liquidity? So a patent is just a piece of paper. It's a piece of paper that recognizes a right. It has really no apparent value. And so monetization is a way of turning this piece of paper into something that's worth money, that can be identified, and that's a liquid asset so that it can be sold. But monetization is more than that. So it's a way to make money, but really monetization, it's a new way of thinking for economists, chartered accountants, CAs in companies, controllers. It's a business model. Monetization is a business model, a way of thinking for a company to take value out of the portfolio of patents and recognize that as a value for the company. And what can the company do with that asset? Well, that's how the business model works. So it's really that monetization is an important aspect for a company. So a company can do research and development, they can obtain patents, they can have lots of good scientists, they can have marketing people, and so on. But when you have all this research, how do you get value out of that? So the business model is for the economist in the company to use in order to figure out how to get the value out of these pieces of paper. So it's really a combined scientific and business approach to thinking. So when do you do this monetization thing? This is a question that I would think you would want to know. Well, first, you do the monetization when you know what you have to monetize. That sounds obvious. So if you have 2 cars in the parking lot for your business and a truck, and there's some liquidity, you could sell the car, you can sell the truck. You know what you have. You have 2 cars and a truck. But for intellectual property rights, often the companies, they don't even know what they have. Because not everything is a registered patent or identified copyright. In a company, everybody's just doing their work. But you have to know what you have in IP to be able to sell it to somebody. But because it's all about knowledge-based economy, so you can't monetize something if you don't know what you have yet. So that's the first step in the monetization process, is to know what you have. It sounds so obvious, but you would be surprised. Most companies, half of their intellectual property, they don't even know they have it because they haven't identified it. When you know what you have, when do you do this monetization? Well, first you need to know what you have. And then you need to know what you want to monetize, meaning once you know what you have, maybe you want to keep some of it and use it in a certain way to make money, or maybe you want to get rid of it. So you have 2 cars and a truck, maybe you're not using the truck. So monetizing the truck means you sell the truck. In the IP business, if you figure out what you have, 2 cars and a truck, or 2 patents and a copyright, then you can decide once you've identified it, well, I don't need that copyright anymore on the database, I can sell that. When do you monetize? When you decide the timing is right. Lots of companies, they accumulate lots of patents and they think, oh, I have all these assets. then after 5 years they realize, I'm not doing anything with this patent, so maybe the time is right now when this patent might be worth something to somebody else that I sell it. So when do you monetize? When you figured out what you have, when you figured out what you want to keep and what you don't, and when the time is right, maybe to get rid of some of it. And when is the time to monetize something? When you decide what you're going to do with it. Because monetize means making money. Maybe monetizing means I'll keep it for myself and I'll use it to make money. Or maybe it means I'll sell it to somebody or lend it to somebody or license it to somebody. You don't know. So monetization is a multi-step process. So if you want to monetize a patent, you have to really be organized and business-like about it. So many clients, small companies, they come to me and they say, I invented something, I want to get a patent, and they spend all their money getting the patent, but nobody's knocking on the door for your business, so you wasted your money, right? Unless you thought ahead about how you're going to use it. So the monetization process is a multi-step process. But it's really broken into two parts. Portfolio management of IP, and then the monetization. Are you familiar with the term portfolio management for IP? Do you know this? Well, I'm going to talk about portfolio management probably for about 20 minutes now, because that's the most important part that you have to learn about before you monetize the patents. So what is the process of portfolio management? So a well-managed company needs to have strong portfolio management techniques. So the first thing in portfolio management is you have to identify all these IP rights you have. So let me give you an example. You have a researcher or scientist working for you in the computer IT field, and he comes in every day and he's working on some software, but he has ideas, and then sometimes he works on something else, and he works on something else. And if I stop you in the hallway and say, your employee, the IT guy, what IP rights, what IP does he have? What has he created for you? Oh, I don't know. He's working on the software program. So you don't know then whether he's developed some databases that might be useful, or some written instructions, or manuals, or he has research that he's assembled. You don't know if he has any of this? No, I don't. So you better go and keep track of what this person is doing, because he probably has developed a lot of IP rights for you that you don't even know you have. Then once you know what you have this much, you have to categorize it. Categorize it like an accountant would do. You categorize your IP. So some of it is copyright. Some of it is patentable subject matter. Some of it might be trademarks, brands, like names of products like Coca-Cola. Or the know-how, it might be the secret formula for Coca-Cola. It also might be trademarks. It could be copyright subject matter. So there's all kinds of IP. You have to categorize it. And then once you categorize each, is it patentable subject matter? Is it copyright? Is it know-how? Is it trademarks? If it's patents, and we'll talk mostly about patents now, in the area of patents, is it for processes, ways of doing things? Or is it patents that cover products? Or is it patents that cover chemical formula? Or the way software is used on the computer? So you have to categorize all of this. Is it in electronics? Is it for telephones? Or is it for radios? Or is it for printers, fax machines? What is it? Categorize everything. So now you've got all your IP categorized on the desk. You have to look at the business plan of your company to figure out well, do I need this? Do I need this? Do I need this? And we'll talk about that in a minute. You need to properly manage your portfolio. You need to figure out, did I do something there that I have to worry about? Should I click OK?
No.
No?
Press the second option. Choose the second option.
Now I do OK? Okay. So you manage your IP rights depending on what your business plan says. And you keep what you need, and you monetize the things you don't need as you wish. So let's just look at a summary of the different types of IP you could have. I don't know if you're familiar with intellectual property or not, so I'll just tell you a little bit about. So copyright, every business has subject matter that could be covered by copyright. Every business calls itself something, it has trademark rights of some kind. Most businesses in technology will have patent rights of some kind. Industrial design, that covers the shape of things, like you could get a design patent that covers the shape of this bottle, whereas regular invention patents, they relate to how things work and formulas, but design patents is the appearance. And then trade secrets are all the processes and formulas that you use in the company that you don't let other people know. These are all different types of intellectual property that almost every technology company will have. So you have to know what you have by starting with the basic categories. Now, this is very confusing, but this is the most important chart because this is how you figure out what you have and what you're going to do with it. So I use this as my own instruction when a client says to me, we have all this intellectual property, we're going to do a sales transaction of the company, we don't know what the company's worth. We have to figure out how much intellectual property you have because I told the buyer this company is very IP oriented, we have lots of IP. The problem is, I don't know what we have. So that's why we call it audit and categorization. So you start with the blue part. This is the know-how. That means that the company's knowledge about its product and its services, it starts with what does it know? And so you go and you interview all the scientists and researchers and say, okay, we need to understand what is it you're doing, what do we know? And then you categorize it, like I said before. So if it's new and useful processes and so on and so forth, it's going to be patentable subject matter, so it would fall into this category. If it's a software and databases, maybe it's a copyright subject matter. If it's raw data, experiment data, and so on, this could be confidential information. That's valuable too. Then it can be general know-how of the company that you can't really identify the way you do things, the way a person does a technique of painting and so on, or whatever it is, that might not be protectable, but at least you need to know what it is. So then, now you've categorized patents, copyright, confidential know-how, more copyright here, and then possibly trademarks. And then you need to decide, well, what do I do with this? Do I get a patent? Do I get a patent, yes or no? Do I get copyright protection? Do I get a registration or something? Do I get a trademark registration? And then it all comes down here, and now these are defined assets. And we'll talk about this in a minute. So then you need to decide, do I do an offensive strategy with my portfolio? Do I do a defensive strategy? Do I do a transactional strategy? It can become very complicated, so I'm just giving you some of the basics. But this is the thinking process that goes into monetization to manage your portfolio.
Excuse me.
Yeah.
Could you explain what is transaction strategy?
Very good question. It's coming, if you can wait. So now I'm not going to talk about copyrights and trademarks. I'm going to talk just about patents because it's pure patent monetization. So I'll give you some examples as we go along. I like to talk about Apple versus Samsung, Apple iPhone versus Galaxy, because everybody who has an Apple iPhone here? Somebody? I do. Does anybody have a Galaxy phone? A few people. So, you know the litigation that's been going on between Samsung and Apple. So, Apple has this patent that relates to the switch on the side of the phone. You know, when you push on the side of the phone up and down, it changes the picture, whatever, it scrolls up and down. Actually, they don't have a switch like that on the iPhone, but Apple has the patent that uses this toggling method. So it's a patent that Apple has that it doesn't use because the iPhone has different buttons on it. But we'll get to that. So, but funny, Samsung uses that switch. So the switch that's patented by Apple, and Apple doesn't use it, Samsung uses it. So that'll be an interesting question in a few minutes. There are also some patents that are not so useful. There are many patents out there. This is a ridiculous patent. This is the patent, the invention for the lazy man skier who can have a motor on his back with a fan turning, and he can go on flat ground like this. This was patented in 1980. I haven't seen this around, but I have seen this. So some patents are very useful, and many patents are not useful. So now you should be at the stage, if you're the CEO of the company, you have that big chart, and you've gone to all your research department and you said, we need to figure out what do we have here, what IP do we have, and what patents do we have, what inventions do we have, what useless inventions do we have, like the fan on the back of the gun back, and what useful patents do we have, like the switch on the side of the phone. And now you have all these, let's look at the business plan. Well, any good company will have a business plan, of course. So the business executives, they decide what direction should this company go in and why, and what are our priorities. So the business plan will define how you use your patent portfolio, right? And the business plan will also decide how you build your patent portfolio to make it stronger. The business plan will clearly say what markets are we in and what markets are we not in. So let's say, I like to talk about Apple because it's a good company. They have the iPhone, they have the iPad, they have MacBook, they have Mac Pro, I think. And let's imagine they have iPrinter. They don't, but I don't. But let's say they have printer technology. They have all this technology in the company. And so the business plan will say, this year we're going to come out with the iPhone 5 or the iPhone 6 or whatever it's going to be. We're going to upgrade the iPad. We're going to make the MacBook Pro stronger. And we're not going to be in the printer business anymore. So that's what the business plan says. And what the business plan says will decide what you do with this printer technology that's patented that nobody's using in Apple. The business plan will usually identify who's your main competition and what you want to do with them. So they'll say, we want to take on Samsung in the market in the telephone technology area. And so this will be our focus next year. And this is where we'll spend our money. So the person managing the patent portfolio will read the business plan and say, well, based on the fact that Apple wants to focus on its phone technology and some of its iPads and not on the printer technology, what IP patents do I need to stop others? So that's offensive technology. So let's say you have patents, you can use them in different ways. Offensive technology, offensive strategy for patents means that you use your patents against other people to stop them from doing something. And we'll talk about that, but that would be Apple trying to stop Samsung. He'll also say, the manager of the portfolio, what patents do I need to protect the company? Patents that are needed to protect the company I just happen to have one here. Patents that are needed to protect the company. Well, we know the patent on the switch on the side, that's not needed to protect Apple because they don't even use that switch. They use two little buttons. So what patents does Apple need to protect its own position? It needs patents to cover the buttons configuration that it uses on its own phone. That's a defensive strategy because it's defending its position so that nobody can tell Apple to stop using this switch. So that's defensive. Offensive is the other switch that only Samsung uses. And what patents do I not need at all? I don't need them. Well, those could be the transactional strategy. Transactional strategy is, I can do a transaction with these patents. Hey, you want to buy my patent? And we'll talk about, that's really where the monetization is, in the transactional side. So the company, based on the business plan, will want to hold on to the offensive patents and the defensive patents because that's what keeps the competition out and protects your own position. The other patents, you can do transactions with them. So that could be a transactional strategy. So that's, you're now managing your portfolio a lot better than you were half an hour ago when I started to talk because you figured out what IP you have, you categorized it, you identified it, then you looked at the business plan, and you figured out what do I need to keep, defense and offensive, and what do I not need at all. So now you're starting to understand how to manage your portfolio. So what is an offensive strategy? An offensive strategy is targeted at the competition. So it blocks other people from using the invention that's in the patent. So with the switch and the Samsung, with the switch patent that belongs to Apple, this is an offensive strategy to use it. Here's our case study. It's an offensive strategy because the only reason you need this patent, you don't need it for yourself, you don't use it. You need it to get Samsung out of the business. So you're going to sue Samsung under that patent, which they did, to get them out of the business. So it's 100% aggression. That's what you need the patent for. So your people invented something you're not even going to use, but you're going to use it to stop somebody else from the marketplace. Because if I can stop the sale of the Galaxy phone because it has the switch on it, there won't be any Galaxy phones being sold, and everybody's going to buy an iPhone. So that's aggressive, offensive strategy. That's what you use it for. The defensive strategy guarantees FTO. Anybody know what that means? Freedom to operate. Defensive strategy is patents for the iPhone that guarantees my freedom to operate. That means my freedom to operate in business and sell this phone. Because if I have patents that cover my own phone, then nobody else can get patents on it. So I'm pretty confident that I can sell my phone as I wish. So that's a defensive position. Every company needs to have a defensive position on its patents, otherwise it's vulnerable in a competitive market, especially in consumer products, because it's all about what is the coolest phone today. And so you might sell the coolest phone today, but tomorrow Samsung's going to sue you because they have a patent on something to do with your phone. So you need a defensive position. So you need to hold on to those patents that you have to be able to do what you want. And if you get those patents, then nobody else can get your patents. And it kind of discourages others from getting in the field. So if you notice, in the telecommunications field, there are fewer and fewer competitors. So it was Apple versus Samsung, it was Nokia and a few others, and they just seem to be disappearing slowly. Their business and market share disappears because Apple and Samsung are so aggressive with getting their own patents. They're fighting, they're blocking each other like this, and everybody else can't come in at all. So between an offensive and defensive strategy between two powerful companies, it tends to keep others out as well.
What is DP?
Oh, business plan. So the arrow up means supports the business plan. So a freedom to operate. So if you have a defensive strategy, you have your own patents, you have a freedom to operate, this supports the business plan. So the arrow up means like this, supports the business plan. Offensive strategy, by keeping Samsung out of the business, it preserves the market leader position for the Apple iPhone. That supports the business plan of increased sales. Sorry, I should have explained that. Another case study, I was involved in this case. It's not my child, it's a baby wearing a diaper. How many of you have children? You know what it's like when they go to bed at night with a diaper on. And so the technology behind a diaper, I worked on this for 8 years with Kimberly Clark. It's rocket science technology in the diaper because it has all kinds of absorption techniques for doing things the baby can do, and the baby won't cry because the diaper takes care of the situation. So, freedom to operate and defensive strategy. The two big competitors in this field are Procter Gamble, which is Pampers, and Kimberly Clark, which is Huggies. Procter Gamble invented elastic waistband for the diapers. So you know if you have baby, you put it on the diaper and it's elastic waistband. It's a very difficult thing to do in a diaper because the diaper is made on a machine that goes faster than you can see the diaper. And they have to put an elastic in the diaper across the direction of where the diaper is going. Bang, 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 like this. It's very difficult to do. So Procter & Gamble invented this concept. And they went to patent it, and they found out that another company called Althaus had the patent already on this technology. So Procter & Gamble didn't have the freedom to operate because somebody else had the patent. So Procter & Gamble went to the company and bought the patent. That was a defensive strategy. It was a monetization strategy by the company selling the patent because the Althaus company, they weren't using the technology. They weren't even in this business. They just invented it by accident. So from the Althaus company perspective, they monetized the patent by selling it to Procter & Gamble because they didn't need it. So they put it for sale. So Procter & Gamble bought the patent. And that was a defensive strategy because Procter & Gamble was then able to make these diapers without worrying about infringing the patent. But then it did something else. Once it got the patent and protected its own position, it then sued Kimberly Clark under the patent it just bought because Kimberly Clark was also selling Huggies with elastic waistband. So now Procter & Gamble took a patent that it purchased for $25,000 to protect itself, and then sued Kimberly Clark for infringing that patent for $500 million. So, just in case you missed that, they paid $25,000 and they sued Kimberly Clark for $500 million under a patent that it didn't even obtain itself. Althaus obtained the patent. So, that was expert portfolio management by Procter Gamble, because Procter Gamble built its portfolio by acquiring a patent from somebody else. Somebody else monetized, they got cash for a patent they didn't use. They would have gotten zero for it. And then they tried to monetize it even further by suing Kimberly-Clark and getting $500 million, but they didn't succeed. But in any case, it was a wise investment. Let's talk about the transactional strategy now a little bit more. Transactional strategy is the idea of generating revenue from patents that you don't use in your core business. So the eye printer patents, Apple's not using them. I'm making this up, but if there were patents for the eye printer, I would say clearly Apple's not using them. And the business plan for Apple says we're going to increase revenues, like every business plan, this year. So how does the patent department help Apple increase its revenues? It helps them by monetizing the patents that are not being used in the company. Let's get some money from it. So we'll talk about this in a few minutes. How do you monetize? Well, basically you can sell it, you can license it, you can do all kinds of things with it, and that's what we'll talk about in a minute. Or you can do joint ventures with it. These are all ways of generating money from pieces of paper that are sitting in the closet, not doing anything. So, I hope I'll explain this right. If you don't, let me tell me if I don't explain it. So DuPont, you know the DuPont company, the huge American chemical company. Are any of you lawyers here? No? 1, 2, 3, 4. Okay. So if you were a lawyer inside a company, you know by now, the company people, they don't like lawyers. They don't like lawyers on the outside either. They just don't like lawyers because lawyers are bad news. And they always say, you can't do this, you can't do that, it's going to cost you this much. So the business people, the CEOs, the controllers, they don't like the lawyers. And at DuPont, it was no different. They had a huge legal department, and they said to the lawyers, enough, you guys have to start generating revenue as a department. So the lawyers said, us? We don't generate revenue. We just tell you what you can and can't do, and we charge you for it. And they get, no. You're going to generate revenue. So what DuPont told them was, go and look at your patents in your patent portfolio and figure out a way of making money. So that's what they did, with great success. So DuPont is a good example of a transactional strategy for monetization of patents that was extremely successful. So what did the patent department do? Well, they sat down. Well, at first they were grumpy, I'm sure, because they had to do some new work that they didn't have to do before. He said, the CEO was telling us we have to make money for the company. We've never done that before. So they take all the patents and they go, well, which patents are we using? The defensive strategy and the offensive strategy. Okay, we can't do anything with those. Those are for us. Now, these other patents, what are we going to do with them? We have a whole pile of patents we're not doing anything with. So then they split the patents up. Okay, you take the chemical formulation patents for polymers. You take these patents, you take these patents. Now, let's go and figure out if any competition is using what's covered by these patents. We never did that before. So then they split it up and they'd say, okay, chemical patents. What are all the chemical companies in the United States? Okay, here they are. What are they doing? Well, they do this, they do this, they do this. This one does a little bit about what we do. So let's look more closely at what that company does and see if this patent might cover what they're doing. Who knows? So it's like a private detective work. So they found many companies doing things that were covered by thousands of DuPont patents that nobody bothered to look at for years. And they went after those companies. They said, hi, we're the DuPont company. We've just noticed you're practicing a process that may infringe our patent. We're going to sue you tomorrow unless we settle. Many times the companies say, we don't want to be involved with DuPont company. We'll settle. We'll pay you a license. They generated, in 1 year, $230 million from patents that were sitting in the closet and nobody was looking at them. They generated $230 million by just trying to figure out who might be using the technology and going after them and negotiating settlements, selling the patents, licensing the patents, monetization of idle assets, monetization of things in the closet that you never use. You know the term garage sale in North America? That means when you open your garage in the spring and you look at all the stuff you never used and you say, I'll sell it for whatever I can get. Well, that's what they were doing. And they $230 million a year. So that's a case study of transactional strategy relating to patents. Now let's just summarize so far where we are. We're still talking about portfolio management. So you start here with the research and development in the company, of course. And then patent prosecution. Prosecution means the process of getting the patents. So you build your file cabinet with patents in the patent prosecution stage. Now you have the portfolio, the file of all the issued patents in the company. So you start with innovation, prosecution, and now you have the patents. Now you have the business plan. This is what we were talking about. The business plan says, this technology is good, iPhone technology is good, iPad technology is good, MacBook technology is good. Let's take the money we have in this area and reinvest it back into innovation. Let's make a better iPhone than we had last year by taking the technology that's done well for us and reinvesting the money in innovation, and then continue the circle. But then there are many patents that are not used, like the iPrinter patents, for example. Let's monetize those. Let's do something with them so that we can make money from these dead files. And this chart is all you need for portfolio management. This is all you need to know. If you're running a company, this is what you need to do. Are there any questions about that so far? Okay. Here's a quote I got today. There are countless patents that are promising but sitting idle, stowed in corporate file room. In fact, some people say 90 to 95% of all patents are unused. So the term monetization kind of was invented maybe 10 years ago to describe the process of what are we going to do with those 95% patents that are unused. So now we're going to talk about how do you do it. So there are basic monetization techniques and there are more advanced monetization techniques. And there are always new techniques that we didn't know about yesterday that we know today. But the most basic one is a sale. So you sell the patent outright to somebody. And for that you need a buyer, and you need an approximate value. You need to figure out what it's worth. And then you just sell the patent. Because you can sell a patent like a truck. You can just assign it, file an assignment in the patent office, and charge whatever price you like. Another way you can dispose of it is you can sell it and license it back. So you say, I say to you, Slomo, you want my patent because you want to use it for something, but I might want to use it, so I'm going to sell it to you and you're going to give me a license back. So I can use what I sold to you, but just me. That happens often. Or sale and structured patents. Slomo says, I want the patent, but I have no money. But I think I'll be able to make some money from it. So I'll say, okay, you can pay me structured payments based on something we'll agree on, that if you generate some revenue, you'll pay me a certain percentage, and you'll pay me as you go. That way, somebody's using the patented technology. The other common technique for monetization is a patent license. So you've all heard of patent license. There are two different basic types of patent license, the non-exclusive license and the exclusive license. Non-exclusive license means that the person you're giving the license to may be one of many persons. So in Russia, if I have a patent and I want to license it, I can license it on a non-exclusive basis, which means that if I'm Apple, I can license my patents on the printer style to Epson, to Canon, to Fuji on a non-exclusive basis, so they can all use my technology and compete against each other. And the price is lower than exclusive license. If I give an exclusive license for the printer technology to Epson, I'm going to charge a lot more because only one person is allowed to use it. So that would affect the royalty rate. So that's another monetization step. Cross-licensing is a situation when you have let's say Epson. We'll put Epson. Let's say Epson wants the printer technology that Apple has. So Apple says, I'll tell you what I'll do. I'll license you to use my printer patents, but I understand you have some patents that relate to some chip technology that have for computers, so you're going to cross-license me back with something else, and it will be zero royalty. So that's a cross-license. The other way to make money from patents is litigation. Lawyers love litigation. So you have a patent, you sue somebody on it, and you try to settle, or you get a judgment for monetary damages, royalties, and that could be anywhere from $1,000 to $100 million or more. So that's litigation is the most popular, well-known way of monetizing a patent. And DuPont is a good example. They had all these patents. They were sitting in the closet, and somebody was infringing the patents. Many companies were infringing the patents. They weren't even bothering because they didn't have time. But they focused on it, and they sued people, and they settled for royalty payments or whatever, and they got money from that. So litigation or threat of litigation is a very effective way to monetize. Securitization. Now we're going to get into a little bit more advanced techniques. Securitization is like a mortgage on a patent. So if you want to borrow money on your house, you get a mortgage, the bank gives you money, and then if you don't pay back the money, they take your house. Well, you can do the same thing with patents in sophisticated banking systems, or especially in the United States, where you can put up your patent as a mortgage collateral and borrow money against it, and then if you don't pay it back, the bank will take your patent. And that works only when you can convince the bank that your patent has a pretty predictable value, which in many cases is not the case, but for some startup companies that have one patent, but for a very valuable invention, they'll be able to post the patent as security. You can also donate your patent to somebody who might want it and get a tax deduction. Maybe not in Russia, I don't know, but certainly in North America, you could donate your patent and put a value on it and get your accountant to figure out what the deduction would be from your company.
How you can count, how you can know the value of when you donate?
The exact value.
This I was going to touch on, and it's a very good question. This is the most difficult thing of all.
I'm not talking about the general situation, but when you want to take a tax deduction, you need to know exact value.
You would need to get a professional valuator to give a conservative opinion that would be accepted by the tax department. So it would have to be done. You couldn't just have your accounting department decide what the value is. You would have to get an opinion of the value. Okay, now these are more advanced techniques, some of which are a bit crazy, but they're imaginative techniques. So, monetization techniques. So one of the more advanced one is patent licensing and enforcement companies. Have you heard of the term troll before? A non-practicing entity? Well, this is the heading that they fall under. And the troll is a non-practicing. They don't do anything. The troll office, the office of the troll, this is the office of that troll company. It's me and some people with money, and I know a little bit about patents. And so I go and find unused patents, like the DuPont patents, and I buy them. And the only business I have is going after other people with the patent to make money from it. And so I'm a patent licensing and enforcement company. Do any of you know the nightmare story for the BlackBerry that involved a non-practicing entity? Where's my... I don't know where I put my BlackBerry, but you know what a BlackBerry is. So Research in Motion, about 10 years ago, maybe longer now, got into the business of the personal telecommunication devices, and they weren't really that interested in patents, they were just interested in selling their product and so on. But a non-practicing entity, patent licensing and enforcement company in the States, they found, they did some research and they found some patent in the closet of some company that nobody was using, and they bought it for a very small amount of money. And then they phoned up BlackBerry and said, listen, you're infringing the patent we just bought. If you take a license this week, we'll give it to you, but next week the price is going up. And the week after that, the price is going up after that. So Research in Motion, BlackBerry said, not interested. You're a troll, you're low life, we're not interested in talking to you. We're an innovator company. We don't need to talk to you. So they ignored them for over a year, and so they sued Research in Motion. Research in Motion said, they're a nuisance, let's just ignore them, they're a non-practicing entity. No judge in the world would think that this company would be sympathetic with this company who just bought a patent to sue us. Forget it. Well, they sued them and they won. So then Research in Motion said, well, we're going to win on appeal. There's no way that the appeal court, they'll understand us and they will reverse the decision and so on. Well, they didn't. So ultimately, the patent and licensing and enforcement company, the troll company, got $640 million from Research in Motion, just so that Research in Motion could stay in business the next day. Because I don't know if you were reading this in the paper, but the injunction was going to issue from the Court of Appeals, and if Research in Motion didn't pay up the money, they would have to turn off all the BlackBerries around the world. They couldn't do it. So they had to write a check for $640 million to a patent licensing company. So that's one, excuse the expression, one hell of a way to monetize a patent. Because this non-practicing entity had no assets one day except the patent, and the next day they had the patent and $640 million, and they were able to go against other companies. So they made a lot of money. So those are the patent enforcement. U.S. court. Yeah. They weren't sympathetic to the Canadians, even if the Canadians saved the hostages in Argo, which is their country. A whole other problem. Patent pools. So once the trolls companies started and got quite trendy, then other companies started creating patent pools. So in patent pooling, companies like Epson and Apple and Canon will get together and say, we want to keep the trolls out, so let's buy up a lot of the useless, seemingly useless patents. We'll put them in a big pool, and then we know the non-practicing entities can't get them, and then if we want to use them, we'll just pay each other a license fee to manage the pool. So that's kind of a defensive strategy more than a monetization strategy. Patent aggregators is really a version of patent licensing, but we would say the honorable style, not the troll style. The patent aggregators are people who decide that, it's too bad I don't have the picture for you, but in the electronics field, there's what's called the patent thicket. There are so many patents out there, you can't even keep track of them all in the electronics field. So patent aggregators will aggregate, assemble a lot of the core patents into one company, and then on a friendly basis license them out to all the companies who are interested in using them. So the aggregators actually fulfill a good monetization role because they go out and they find all the objectionable patents and they pool them all together, and then they offer licenses on reasonable terms to all the electronics companies who want to use them, and they make a lot of money at it, and it's kind of a value-added service. We're almost done here. So there are two other types of companies or businesses that get a lot of money out of patents, and that's IP type development companies and university tech transfer companies. So these are companies that they don't practice anything, but they do focused research and technology development that will be of use to other companies like Apple and Samsung. So IP tech development company would be like companies that develop the multitude of applications that you can get for your phones that have nothing to do with the Apple company, but they're compatible with Apple company. And so their monetization technique is to piggyback on established technology company technology and figure out ways of generating money by patented technologies that are of assistance to the main technology. So universities do this a lot. They do a lot of research in the research departments with the students, with the professors, and they capture all the IP. And then you have the IP, now they need to do something with it because the university is not in the manufacturing business, so they will license it out. So this is a way for a university to generate revenue, stimulate research and development. So a lot of the universities and tech development companies are supporting the major technology companies and making money from it this way. The other two things that are trendy in the United States are IP auction houses. So you can actually go, there's a company called Ocean Tomo. If you don't know it, you can go on the website Ocean Tomo, Ocean T-O-M-O. And they are a professional auction house. So I just got invited to one of their receptions in California. They say we'll have a nice dinner, and then after the dinner we're going to auction off patents. And this has been quite popular for the last 5 years or so. And anybody who wants to auction their patents, bring them along. And then it's an open process. How much do you want for this technology that relates to clearing ATM machine, bank requests, whatever. So those are IP auction houses. They're becoming quite popular because you can bring whatever you have, your closet full of patents, and you can advertise them and market them, and people can look at them and evaluate them, and then just auction it off. Online IP exchanges is like a dating service on the internet for getting rid of your patents. They have these websites where you can just put your patent up and say, this is a patent I'm willing to part with. I'll take money for it, or I'll exchange it for something else. Maybe a bottle of vodka or something, whatever it is. So this is another way to monetize your patents. A couple of other things. Monetized technique is IP-backed financiers and securitization firms. So there are firms that are specialized in evaluating IP rights of others, and we'll come and take a look at them, read them, evaluate them, and say, okay, we'll lend you money on this patent. Based on our experience, it's worth $5,000, $50,000. We'll lend you $10,000 against this patent. So they're like specialist banks or credit agencies that evaluate patents. Also in the insurance business, insurance companies in the US especially will take a patent as collateral for giving you insurance on your company, fire and theft or whatever. We'll do this. Technology spinouts, that's actually more important than the last few, and it's kind of buried in there. That's this. So monetizing. So as you probably know, Apple will decide, their business people will decide, like, we want to stick to what we do best, is this. We have all these printer technology patents that we thought someday we might get in the printer business, but we're not going to. So let's take all these patents and we'll transfer them to a company called Nuco, and we'll offer Nuco for sale. So we'll spin out the printer business to a company called Nuco, and we'll try to sell it to Epson. So Epson will pick up Nuco and merge Nuco into Epson. Now Epson has all the printer technology of Apple. So that's a spin out, and that's probably one of the most important monetization techniques, because they're taking the technology, they did the whole portfolio management, they categorized everything, they put all the printer technology in one place, they formed a company, and they sold it off, and they made a lot of money. I made that up, it didn't happen, but it happens every day with lots of companies.
How is it different from just selling this set of patents? Why do they need to form a company and sell it as a company?
It's a good question. So, in this case, I probably should have developed the example a little bit better. In this case, I was explaining they just had the patents, so they could just sell the patents, right? But in most cases, they will have the patents and a little bit of a business going on. You know, they'll have an office and maybe a small manufacturing and sales facility, so they'll have more than just the patents. They'll have the patents and the operation of the company that they want to spin off. So IBM was in the hardware business with laptops, and Lenovo owns that whole business now. So they just said, we don't want to be in the hardware business anymore. We want to be a service company. So with lots of patents on the computers, so we can't just sell the patents, we're going to sell the whole business. So in that case, IBM took the whole laptop business with all the patents and spun it off completely to another company. So that's, to answer your question, that it's if you just had the patents, yes, you could just sell them. But if you have the patents and a bit of an ongoing business that isn't that profitable, then you would sell the whole, spin off the whole company. I believe that's what another Canadian story we're very sad about is Northern Telecom. Nortel was a huge technology-oriented company, basically went bankrupt. So they sold off a lot of patents, but they also sold off a lot of businesses. So they took, Northern Telecom was huge telecommunications company. They took big pieces of the company and said, okay, this whole piece of the company, we're just going to spin it off. And BlackBerry, Research in Motion, they're thinking of splitting the business into two parts, the hardware business and the services business. The services business is managing all the data that goes on your BlackBerry, and the hardware business is the BlackBerries that aren't very exciting anymore. But there's patents covering both. So to spin it off, they take all the patents and they would put it into a separate company along with the ownership of the hardware technology company, and they would spin off the whole thing and sell it for $1 billion or something. So that's really what I meant. Patent brokers, they're like real estate agents. They're in the business of selling patents to people. So you come to a patent broker, the patent broker says, I want 10% on anything I get for selling the patent, and I know the customers who would like this patent. So I'll monetize the patent for you by selling it to IBM. I think I know the people in the company, so that's like selling a house for real estate. Now, the last thing I want to talk about is valuation, and I think you brought that up. So all this monetization is really nice, but you can only make money if there's a willing buyer and a willing seller, and you need each one, the buyer and the seller, need to have an idea of what is this patent worth. And that is not like a truck, because if you're trying to sell the truck, in my example, you can look it up in a book, what is a 2005 truck worth with 100,000 kilometers. You know what it's worth, you just look it up, that's what it's worth. If I want to monetize the truck, this is what I can get, and the buyer knows it and the seller knows it. But for patents, there's nothing to go on. So how do you value a patent? The other problem in many countries, generally accepted accounting principles do not allow you to ascribe a value in your books to a patent if you invented it yourself. So if you have a company and you develop a patent to technology and you're using it in your own company, you can't have a value on the asset sheet for that patented technology because it was grown at home. So that's another problem in valuation, because you can't say to a potential buyer, well, I can tell you what it's worth because it's in my books, it's listed in the books at this value. So that's another problem. So patent valuation is a whole other area of expertise. So just when you thought you had enough with patent lawyers, now you have patent valuators who could be lawyers but might not be, because evaluator has to have one part of his brain, he's a patent attorney, because he has to understand how the patents can be read, and he has to be a bit of an economist, and he has to be a financial expert. So evaluation is a specialty business that companies like KPMG and other companies have. There are many independents, and they look at many different techniques. Here's just a few. The easiest one is if you have a patent and you're taking licenses from it, from other people, and you want to sell it, well then the discounted cash flow method is very easy, because you just figure out, well, what is the royalty stream? What is that worth over the life of the patent? What's the present value? That's how much I want. So that's easy. Most of the time it doesn't happen that way. Litigated patents. You look at, well, if they were litigated, what kind of money did you get from them? And you can sort of get an idea from litigated patent how much it might be worth based on lawsuits that you've had against other people. Citation frequency. In the patent world, when you have a patent, it's in the patent office, and it's accessible around the world to the other patent offices. And every time somebody wants to patent something, if it's already covered in your patent, it'll be cited in the new patent application, and it's called a citation. So some people think that if your patent is a pioneer patent, a very important patent, it's going to be cited by many other patent offices as a reference that will block somebody else from getting something. So that is an indicator of value. Some people use that as an indicator. Maintenance fee history. In patents around the world now, you have to pay every year, you have to pay a fee to keep it alive. So some people think that the longer a patent has been kept alive, the more likely it has a higher value. So if a patent has a 20-year life, and somebody's been paying the maintenance fee for 12 years, they must be thinking the patent is worth something, and that's another indicator to drive up the value. But these are all soft indicators. They're not hardcore indicators, so they're just indicators, approximators. So that evaluation is very difficult in the monetization process. The other way of looking at it, which I didn't put it here, was how much is it worth to the other guy? So this is mostly how much is it worth to me. But if the patent covers somebody else's technology, like Apple's technology for the iPhone, and I'm not using the patent, it might be worth zero to me, but it might be worth $1 billion to them, because the patent might be worded such that it covers what the iPhone does. And so the other way of looking at it is, what is it worth to Apple? So the evaluator will look at, well, this patent is about 1% of the annual gross revenue from the Apple sales of the iPhone, so it's worth whatever that would be in millions. So that's another indicator for valuation. But it's all a very subjective way of looking at it. Now, I'm going to scare you with one more slide and then I'm finished. And I don't know if you understand what I mean when I say I'm going to scare you, but so who are the players in this whole monetization process? Who is interested in monetization? And this is who's interested. And that ought to scare you. But I'm just going to take 1 minute to explain it to you, and you don't have to be scared. Don't worry. So let's assume it's iPhone versus the Galaxy. Those are the two products up here. So this is the iPhone. This is the Galaxy phone. So let's go down the levels. So first of all, there's the brand owners. There's Apple and Samsung. They own the names for the phones, and they own the design of the phones. So they will own some patents and trademarks for the two phones. But they don't do everything about the phone. They get the phone manufactured for them by somebody in China. It says right here, designed by Apple in California, assembled in China. So somebody made this phone for them. Those are the manufacturers. Well, they'll have their own patents on how they manufacture this the most efficient way possible. But the manufacturers, they don't make all the parts, they just put it together. So all the pieces of plastic, the screen, the buttons, the inside, it comes from this supplier, and that supplier, and that supplier, and that supplier, and that supplier. So there's three basic levels that are required to bring this phone to the market. It's not just one manufacturer who makes everything. And all these various suppliers, they're supplying at the same time to Apple and Samsung. In fact, Samsung's even supplying parts to Apple for the Apple phone at the same time that they're ripping off the Apple phone. So it's all very incestuous, and everybody's got patents all over the place. So in the monetization process, these suppliers, they have very low margins. So they've got patents all over the place. They go like, so supplier 1 talks to supplier 2, you know what, I don't need the switch technology. I'm not doing that anymore. I'm just supplying screens. Would you like to buy the switch patent? Yeah, I'll take the switch patent, but I've got a screen patent. Why don't you take my screen patent? So they're all cross-license each other until at this level, at this level, and this level. And then on the outside, there are all these people I was talking about. The universities, they're saying, the Apple iPhone, we want in on this. Let's do applications and so on and so forth. We'll sell them, and we'll sell them. So the outside companies are also supplying into the supply chain. The patent trolls, they're like the birds flying around. They're going like, how can I make money from this? I'm going to find some patents that I can use to sue Apple and Samsung, and I'm going to make some big money. And then over here, bankruptcy people are looking at, well, this company is going to go in business, and I'm going to get their patents, and I'm going to sell them over here to this company. So I'm going to make money from that. The banks and the lenders, they're also looking at where's the valuable patented technology in here. Maybe I want to lend money to that company. Then there's the valuators I was talking about. They're looking in here too. The valuators are saying, well, there are lots of patents in there. I'm going to value all that stuff. I'm going to make a lot of money. So everybody's monetizing. Everybody's deriving revenue from the process associated with this. So I hope that was more interesting and not as scary as it looked at the beginning. And that's it. I hope it was interesting. And if you have any questions, please feel free to ask.
Thank you very much. Any questions, but please use the microphone.
Я буду с места.
Technology,
How often do insurance and securitization firms lose their money? Do you happen to know?
I don't know for a fact. I would say that some securitization firms take some, it's all about risk assessment. So depending on the terms of the security arrangement, some companies will take higher risk thinking that they can use, if they have to, they can use the patented technology against somebody. We've had these things happen in Canada. So some securitization firms, they will look for low risk, and in which case they won't have a problem. But others are really looking to get the patents. They would like the company to fail so that they could keep the patent and then use it against somebody else. So it's all about investment banking type of approach. It's not really technology approach. It's recognizing the value in the assets and deciding what kind of risk you want to take and what potential return you can get. So in that sense, there have been failures that have been what the lender wanted to have happen. But I can't think of anything specific to tell you, I'm afraid.
Okay, thank you.
My name is Konstantin. You're talking about companies, different sizes, but I can understand how when company need to start to think about patents, because for example, startups have no money even for make patents to register, but they produce so much how knows some new technologies that should be patented because they need to protect their growing business after some stage from the CEFIR, from other companies, or from acquisition from big companies just by patents that they start up maybe use for their core business.
It's very difficult for a startup in this case because there are lots of big players in the industry, and so what I always tell the startups is they'll usually have a certain amount of cash that they've gotten from some kind of financing or investment pool, and they'll want to get patents on everything and trademark everything. And I tell them that's a wise thing to do, but don't do it. Just patent the core thing that relates to what you do, and nothing else. And what do I mean by that? So I mean, when you come to me, you're all enthusiastic and you have maybe $100,000 in your pocket because that's your startup capital, and you think you need to patent everything to protect yourself. And you really only need to patent what is the core thing that you've done and nothing else. So what you should do is you file a patent application, and then you let it sit, because you can let it sit for 3 to 5 years in most countries and do nothing with the patent. You just filed it, that's all. You pay the basic fee to get the patent on file and nothing else. Now, take the rest of your money and focus on developing the business and attracting interest in the business. And this is where you can develop the company further and get more investors based on the fact that your patent application, which you can show them because you filed it, it's protected now in the sense that nobody else can file it and get ahead of you because you filed it, you have your date. But you can, if your business is starting to, if your product is really starting to work, then your patent application that you filed will start to increase in value. And when other investors look at your patent, they'd be more willing to invest in the company because they see the value of your patent. This happened in the internet boom period. I'm old enough to remember before the internet and during the boom and after the boom. And so before the boom, everybody was just patenting chemical things and manufacturing processes. And then all of a sudden the internet came, and there were a few patents that were issued for techniques of doing things on the internet, software-based things, of course. And so all of a sudden the startups were all over the place. All of a sudden everybody was phoning us from nowhere. They're just phoning us, I have to see you today, I have to file a patent tomorrow, and I need it right away. So what they would do is they would have a patent application filed, and then they would go and try to sell it. And we would have large companies coming to us to see our client's patent application, to see if they should buy the whole startup company right off the bat, based on the patent application only. And so why am I telling you all this? Because you only need one core technology patent really to put the value of the company where it needs to be and to protect it, and not anything else. And then you can use it to get investors. Can you afford, with a little startup company, to take that patent and get it issued as an issued patent and then go after Apple and Samsung? Probably not. But if you're determined enough, you can build up your sort of investor pool, and they will help you go after Apple. And then Apple will start to notice you all of a sudden, and they'll probably buy you out. And then you start something else, or you give them a license. So it's a delicate situation, but it's not like the old days where you've got a patent on something and you're rich and everything's fine. There's patents all over the place, and so it's a complicated process.
It's easy to understand about not to be very enthusiastic about patent, but my question is, if you start something, you even don't know, do any big companies have the same patents in their pools, and they just do nothing with them? But if you're growing, or when you try to patent, you may reveal that it is already patented.
Yes.
I think that's the problem for now, because they makes hundreds of thousands of patents. Every year they makes 2,000 or 3,000 of patents.
Yes. There's a picture, I wish I had brought it. It's called the patent thicket, and they take all the electronics companies, like, let's say, this is, you know, Apple, Samsung, and then there's so many companies like this, and they all have patents, and the patents are covering like here and here and here and here and here, here and here. It's like a fish net, you know.
Okay.
And you're right what you say. So like this company says, you can't do that because I have a patent on this, and they say, well, you can't do what you're doing because I have a patent on this. And then this guy says, well, neither one of you can do this because I have a patent on both of what you do. And then this guy says, well, yeah, but I have a patent on what you do and a patent on what you do, so you can't do that, so nobody can do anything. And this is a complaint right now in the United States patent system, that the patent in electronics field, the patent system has gone crazy and destroyed itself. So according to this, nobody can do anything. And so it's a bit discouraging in electronics field. Before the electronics field, you know, in the more stable sort of manufacturing sector and things, it wasn't as much of a problem because there weren't as many people getting as many patents. So you could know what your competitors had, and you could steer around that and do something else. But now it's become crazy. So some people say it's too easy to get a patent in the electronics field and then block everybody else, and then nobody can move. It's like a Mexican standoff, you know, the guy's got a gun and three guys have a gun at each other and nobody can do anything. So that's not good news, but that's kind of the reality of the situation right now.
So maybe it is possible that they just, never mind, make your own business. I don't want to make any CEO or maybe law enforcement for your business, because I have so other companies that I need to sue the small companies. So
yes.
My question is any cases of a small company which has some problem with big companies with the patents?
Many cases like this. So there are cases where the little company is trying to stop the big company, and the big company has a lot more money, so they don't care what the little company thinks. Sue us, they say. You don't have the money. There's that problem. And then there's the problem with the big companies going after the little companies to get them out of business completely. So it is a problem both ways. And there are many people who don't believe in the patent system because they think that it's being abused now. It used to be a good idea because it was rewarding inventors for things that they did, but now it's just about money and monetization and nothing else. So this is a tension that exists right now. But for a small business person, I'm not giving you very good practical advice. I mean, the practical advice I can give you is, if you're in a small field, you need to know what other people are doing, so you need to research the patent system to find out what are the patents out there, what is the activity, what contribution can I make to the businesses in the industry, how can I make money, and what do I need to patent to protect my position, but not get involved in this big mess. So it's not easy.
Can I ask you a much simpler question about IP not necessarily patents? Suppose I published a book in Toronto, Ottawa, textbook in economics of intellectual property rights, right? And then somebody in Moscow or some other place here publishes another textbook in Russian, which takes part of the material I used in my book in Toronto. What happens then? Where is the protection that happens?
Well, fortunately, there are international conventions for most types of intellectual property rights, patents, trademarks, copyright. And this question you ask falls into the realm of copyright. And under the Berne Convention, of which Russia is a member, they say, we will recognize the copyright of your country for your people, and you will recognize the copyright for our people, and so on and so forth. So what that means is that if a person publishes a book in Russia that copies a book in Canada in part, then they would be infringing the copyright of the Canadian copyright owner by publishing the book in Russia if there was a substantial taking. And the Canadian copyright person would likely have recognizable copyright in Russia for the Canadian work under the convention. So you could choose to sue that person strategically either in Russia or Canada, depending on where the act took place. Depends on the circumstances. But I guess what I'm saying is there is copyright for the person who created the book in Canada. There is copyright that exists in all the other countries who are members of the Berne Convention. And therefore, if your copyright from Canada exists in Russia, then if somebody copies it in Russia, you could sue them in Russia based on your Canadian copyright.
Thank you. Maybe. Okay, for two questions then, yeah. Thanks.
Thank you, David, for this.
You first.
You go first?
Okay, sorry.
I've got two questions. I was thinking about these Apple suing Samsung, that they sue them for the patent that they don't use at all. And I was thinking that isn't it, I don't know how it's in English, like the use of right or de droit in French, that you just patent something and you don't use it. Is it a patent? Or is it a real patent if you never use it? And the second one, that is it de droit in case that they patented after they constructed or designed it already in Samsung, if they prove that they designed it before, but they didn't patent it because they didn't care.
Right.
Is it regarded this way or not? And the second, just the same, how in America, in the US, laws regard, for example, patenting or buying some addresses in the internet. For example, some, I don't know, apple.ru. And in Russia, they did it best. Because they prove that they have used it already.
Okay, so there are a number of questions there, and there's some good ones. There are time limits within which you have to file your own patent application. And usually the time limit is 6 months or a year. Or let me explain it another way. If Samsung does the button first, then Apple can't go and get a patent on the button that Samsung's using because Samsung's already made it public. So a person can't get a patent on something that somebody else has already made public. Can't do it. So Apple can only get a patent really on what it invented itself. So it can't go and find that what Samsung's doing and patent it behind its back. It can't do that. And then the abuse of patent rights you're talking about, yes, there are laws everywhere. There's a law like this in Russia. There's a law like that in Canada, the United States. Typically, it's very difficult to prove that if you have a patent on something and you're not using it at the time, that this is an abuse of patent rights, unless you can, I've never seen it proven, even though that law exists in every country, but it's there on reserve. So, if Apple can show that it had a good reason to get the patent that it did, which it would have, because they would have had a designer who designed the switch, they got a patent on it, and then they thought, well, you know, I don't know if we're going to use that right now because the focus group in the marketing department said that people don't like those switches, they like buttons instead. So we're not going to sell it right now. But maybe we will next year. But in the meantime, Samsung does its own market research, and they say people in Asia, they love these buttons, so we're going to make that button. So then, to say that Apple is abusing the patent rights would be a very tough case to make, because Apple could just say, well, you know, we're not using it today, but we might use it tomorrow. So really, you can't say we're just doing this to target Samsung. So theoretically, what you say makes a lot of sense, but in practical terms, it rarely succeeds as an argument. So it doesn't really happen. And all Apple has to say is, well, we would be willing to license that switch to, not to Samsung because we don't like them, but we would be willing to license that switch to that company, to Nokia. And as soon as they license it for $1 to Nokia, that's considered to be using the patent, even though they're not doing it themselves.
Sure. But if they didn't do anything, if
No.
nothing,
Yeah.
and if it is, well, the third consideration, if it is that simple that, well, nobody would care about it, like patent, if just nobody goes into the mind just to license the depth of the metal carving or something like that.
It has happened, but even in those cases, the courts, at least in Canada, they haven't invalidated the patent or said that it was abuse. They've just limited the relief that the patent owner can get. I'll give you an example. Procter Gamble was into big lawsuits about who were they suing? I can't remember who they were suing, but they were making these little cloths that you put in a clothes dryer, and it makes the clothes softer. It's called fleecy, I think it is. Anyway, it's a product that's in North America. So if you take something out of the dryer, like a towel, and it's rough, it doesn't feel good. So they had technology where you put this little piece of cloth like this in with the dryer, and then it goes around and it puts a softener on the clothes, and then you take it out, it feels good. So this particular technology, Procter Gamble was not using at all, and they sued this rival company, I can't remember who it was, and the court said, well, I don't like you, Procter Gamble, because you're not even using the technology. I really don't appreciate you coming here after 10 years and not using it and suing. You're clearly just trying to block somebody else from using it. So instead of saying, I won't enforce the patent, they said, we won't order this other company to stop doing it because somebody should be practicing the patent in Canada. So we'll allow them to continue, but they have to pay you a royalty. So the technical term was, the judge didn't grant an injunction preventing the use, but he granted damages and an ongoing royalty to be paid to Procter & Gamble.
And who estimated it? Because the judge would make cost more.
Pardon me?
But who estimates the damages? Because the
judge
damages might cost more.
It's always about the judge has to evaluate this based on expert evidence. The judge listens to experts. Procter & Gamble's expert would say, oh, the damages were incredible, and the other company would say, no, there was nothing. And so the judge has to evaluate this difficult task.
What you just said almost answered my question. So thank you. Thank you very much for your lecture, and especially interesting what this last scary picture.
Thank you. Thank you very much. Very much enjoyed it.
Probably the materials you want to.
Yes, I have some brochures, but they just talk about our firm. You're welcome to take one, take a look at it. They are in Russian and English. So, and thank you very much. I really appreciated speaking to you.